And I will tell my coworkers I just turned on the start recording button because that's a good thing to do in the beginning of a presentation. I'll go over a few of the logistics today, just so and I'll do it as quickly as I can so we can get to our wonderful speakers as quickly as we can. If you're disconnected from the webinar at any time, just go back to that email that you got early this morning and click on the link again to log back in. And if you have any problems getting back on, please call iLink support, and that's at 800-799-4510. And Dot, one of our assistants, our assistant for today's webinar, will put that in the chat box. Thanks, Dot. Okay. Talking about the chat box, that you'll see that down in the lower left-hand corner. So why don't we give it a little whirl? I know many of you have been on webinars before, so you know how to use this. But it'd be really helpful if you would type in your where you're calling from. Your name will come up, so you don't have to say your name. Say where you're calling from, and if you have more than one person at your station, at your site, if you could let us know, that would be very helpful. Michael, is that better? Michael asked for it to be a little louder, so I will try to do that. Okay. And if there's more than one of you, just let us know, please. I always like that Linda Barnard's always on with her dog. Say hi to Emma. So you see people calling in from all over the country. I hope those of you in the middle of the country are doing okay with all that terrible weather. Gosh, anyway. If you're joining us by phone only, please email Dot with any questions. And her email is dot.dot@ncdbw.org. And we are recording today's webinar, and I actually turned that recording on, so I'm very proud of myself. And so you'll be able to access this webinar and others in this series on our website, which is ncdbw.org. And we'll put that up in about a week to 10 days. And Dot will put that in the chat box down below. We have posted today's PowerPoint in a version that you can save and or print, unlike this that you're seeing here, and bios, longer bios of our presenters today. And they're on Google Drive. And that link was in the reminder note that you got this morning, and Dot will post it again. And if you're signed into iLink, you don't need to get the PowerPoint right now. You can get it later if you want to save it. You've also probably noticed that this webinar has closed captioning. To make it appear or not, please go up to the upper right-hand corner of your screen. You see there's a little iLink logo there, and then there's a couple of other little symbols underneath of it. The second one over says CC, and you can then click on the little arrow, and then it says hide or show, and you can change the size of the captioning, etc. So if you need to either turn on or off or change the size and the font of the closed captioning, you do that up there. And many thanks to Marilee Johnson from Paradigm Reporting and Captioning for providing our captioning today. And then at the end of the email, soon after it's finished, we'll send you a confirmation of your attendance, and we'll also send a link to the recordings and a very brief survey. And that same evaluation will also pop up at the end of the webinar in case you prefer to answer it immediately. So it's very helpful to us and to our speakers if you take really probably 4 minutes, 3 minutes to fill out the survey. The feedback is very, very helpful, as I said. So right now we're going to see if this works. We have some questions for you. And we're going to try to get them to come up. We may just skip these questions today. I'm going to give this a sec here. The questions are not appearing. So we'll just, what we wanted to ask you is really, have you ever participated as an expert witness? And we use the word participate on purpose because we know sometimes people are involved in cases as expert and they don't go to trial. So if you can just tell us in the chat box, and Marianne and Dawn, if you want to take a look over there, going to the public to look at this part of it, that may be helpful. So it looks like there's some interested, not yet, but it's mixed. Okay, that's helpful information. And just very briefly, those of you who have said yes, how many of you have participated in a trial where you have done person-specific testimony, and mostly, I would imagine, defendant-specific, where you evaluated the individual defendant? So if you could just let us know if you have done an evaluation. And Marianne and Don, I think this may help just to get a little sense of who is on here.
Mm-hmm.
Okay, that's really helpful. Thank you very much for taking the time to do that. And I'm sorry that our polling questions didn't work, so that makes it a little more complicated to get the answers quickly. So again, if you're only participating on the phone today, you can send in information and questions and your answers to whether or not you've testified, and if you've testified on behalf of an individual victim of battering where you did an evaluation, you can send your answers to dot@ncdbw.org. Okay, thank you. For those of you who just signed on, again, I'm Sue Osthoff with the National Clearinghouse for the Defense of Battered Women, and thank you all for joining us today for this webinar. And this is actually the 11th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and or other forms of trauma. And if you missed any of our earlier webinars in the series, recordings, and those recordings pull up copies of the PowerPoints once you start listening to it, are posted on our website at ncdbw.org. You just go to the website, and there's not much up there. Go to resources, and then you'll see where the recordings are. You've probably noticed that all the participants are muted, and as I mentioned earlier, we will be collecting questions during the presentation, and time allowing, we'll then ask as many of the questions as we can to our presenters at the end of their presentation. Before I go any further, I want to just take a sec to thank the Office on Violence Against Women for their support of this project on expert witnesses. We just think it's really great that they're supporting work about this very important topic, so thanks to OVW. So without further ado, today's webinar is titled Expert Witness Testimony in Cases Involving Domestic Violence. And as you know, our speakers are Dr. Ann Dutton and Dr. Dawn Hughes. Let's just go to the... And these, sorry for the small type, and these are really short bios of these two very impressive presenters and impressive expert witnesses. And on your Google Doc, there's some longer bios of them. And in an effort to save time, I will do only a very brief introduction of them, which I really have to say it's extremely difficult because they both have so much relevant experience. And I'm really, frankly, a very huge fan of both of them for so many reasons. Not only because they're both really super smart, but they're also unbelievably generous with their time and wisdom. And I consider them both to be among some of my most influential teachers and mentors. So I really do mean that. I do encourage you to read their full bios. You may want to even Google them to get more information, and because there's lots of impressive experience there. And I usually write up a little short bio for the speakers, and I really was struggling with writing up something short about these two because there was just so much to share about these two amazing experts. And I wrote up this thing, and I was like, and I don't usually even share it with the speakers, and I sent it to Dr. Dutton and Dr. Hughes, and Dr. Dutton wrote back, and she said, I think the most important thing to say is that we've just done this work a lot, both expert testimony, understanding the process, but also sitting with victims and perpetrators. And we try to understand the complexities of human behavior, understanding the content. That said, I never cease to be surprised by all aspects of all of it. And then about 2 minutes later, I got an email from Dr. Hughes saying, agreed. So I thought that's what was important to share. And because I think it does really sum it up really nicely, that it's not only all of their very rich experience. It's also how they do the work that's really important. So I'm not going to spend time talking about all the research they've conducted, the publications they produce, the presentations they have done in the specific areas of concentration. Really, all I'll say is they have participated in in cases as expert witnesses in, hundreds of times. And so I'm going to let them talk about that more themselves. They are really among two of the most experienced and skilled expert witnesses that our office knows. And I just feel like we're really lucky that our office gets to work with them so frequently, and we're all very lucky to have them as speakers today. So thank you so much, Dr. Dutton and Dr. Hughes, for all your great work. And really, thank you so much for your willingness to share it with all of us today. And so without further ado, I'm going to turn it over to the two of you. So thanks.
Well, thank you, Sue. That is very kind of you to say all of those things, and really appreciate the comments. I hope that we are deserving of them. I think what I need now, there I go, to be able to advance the slides, which I just figured out how to do. The overview of what we hope to talk about today is on your slides. So we're going to divide between Dawn and I some of this content, although we'll be going back and forth in commenting on what the other has to say. But we'll begin with the beginning, which is really in the beginning deciding about whether to be an expert and what kind of advanced preparation one needs to make in each and every case for deciding in that case to take on a case and to potentially provide that kind of testimony. We'll then go to part two, which is the work that has to be done prior to going into court, which is a lot. And then we'll advance to part three, which is really talking about how one conducts oneself on the stand. That is the process, which I think in many respects is often as important as the content, or at least, shall we say, the content can't be delivered particularly effectively without a very effective process. And then in part four, we'll be talking about navigating both the direct and the cross-examination. So without more of that, let's go to part one, advanced preparation for testimony. So in the beginning, I noticed in the chat box, many of you haven't actually yet decided or have had the opportunity to do expert witness testimony. But even if you have, I think each time that a case comes my way, I really make a new decision about, do I work in this case as an expert witness? Partly, or largely, that is determined based on simply knowing something about the case and knowing what it is that my expertise can allow me to do, and perhaps even more importantly, of knowing what my limits are in terms of being able to provide expert testimony. So there are lots of things that I might think that I know something about and perhaps do, but that's a different matter than being able to get up on the stand and suggest that I have expertise in that given area. And that's really what it takes, which is to be able to point to something that supports the fact that I have expertise in that area, not just that I might happen to have an opinion about a given topic. And so the first part of the process really is to determine what is the expertise that you might have and what's the basis of that expertise. And generally, there are sort of two bases that are very important, one being education or training in a given area, but the other is also experience. And so those two may have a different combination for different people, but it's important to know what is the basis of that expertise and what's the basis of that experience. And I mean that in a way that suggests not just, well, I've had X number of years working in this particular setting, but drilling down so that in anticipating how you might be challenged, what exactly is that kind of work, and how many people have you worked with this particular kind of characteristic or behavior? What kind of training specifically have you had, even though you may have this academic degree? What exactly was your training in this particular topic? So those are things to consider, and although it can sound daunting, it's not particularly. And it's very useful to be able to distill what is your expertise and your limits of expertise, much like in an elevator speech, to be able to really be succinct, to be clear, and to know, again, what's not part of that framework. Much of this gets clarified, if you will, in that very first consultation with the attorney. And I think that this is perhaps an overlooked point in the process that isn't discussed much in trainings around expert testimony. I've very often gotten first calls, and the attorney may say something very general like, tell me about the case. I have a woman who was charged with shooting her husband, and so there's this general sort of request about something regarding battered woman syndrome or battered woman testimony. But that's really not the answer to the question of what is it you want from me about this case. And so in some respects, this is an iterative process because often an attorney doesn't really know what she or he needs or has to work with or wants at the point they call you. And so it's often the case that they can't actually answer fully that question until sometime later when there's more information available, perhaps part of the information coming even from an interview, although we're not really focusing on that part of it, part of the information coming from further conversation with you as the expert. And so, again, I think this phase of the process is really important because you may find that your expertise goes a certain distance, but it doesn't actually cover everything that needs to be addressed. So, for example, if you have expertise in domestic violence, but you don't necessarily have expertise in substance abuse, you may only be able to offer your expertise pertaining to one issue and not the other. Now, in some cases, that becomes a problem because you need to consider all the facts, perhaps substance abuse being one of them, really to determine or to influence the decision about domestic violence. But if there's a serious mental illness issue, or if there's a gambling addiction issue, or it could be anything for which you may or may not really have that expertise, it's very important to discuss that with the attorney so that if there needs to be a second expert, or perhaps you're not the person for the case, that can be decided as early as possible. So there's not only the question of what is the attorney looking for in your expertise, but what does the attorney want to accomplish? And this is a question, by the way, that usually comes a little bit later in the process once you're on the case and have done some work with the attorney. What do they want to accomplish with your testimony? And so again, this can risk becoming kind of a general, I just want you to educate the jury, or I just want you to educate the judge about these myths. Well, what in particular is the attorney interested in clarifying for the judge or the jury? So in some cases, that becomes an easy task to accomplish with an attorney, and sometimes that becomes a much more difficult task. But it's certainly important to press for that specificity the extent to which you can. So continuing on with the advanced preparation, this is a little bit preparing for the testimony itself. Preparing for direct questions and preparing for the indirect questions are two very different processes. The direct questions are the far easier of the two. You know what it is by this point that you can say about your opinion, about your conclusion. Seems fairly straightforward. It's a lot like teaching. And the indirect questions, on the other hand, are the issue of how to respond to the various kinds of challenges to the answers that you might provide. So the challenges can come based on the content. So for example, Dr. Dutton, aren't you aware of this such and such study that says exactly the opposite of what you just said? Or Dr. Dutton, do you know how many studies made that conclusion versus studies that made a different conclusion? Or it can come in terms of challenges to your expertise directly. So you don't really have expertise working with battered women from Alaska, is that right? That kind of question. So it's very, very important to take an opportunity to become your own devil's advocate, if you will, in looking at where all the legitimate challenges to your testimony might be, where the real limitations are, and then also where the strategic challenges might come that are simply intended to undermine your testimony or your expertise. So here, it is very important. Again, you're going to use what you have worked with in terms of your relevant expertise and knowing when to say, that's not something I have expertise in. Mostly, again, directed to indirect questions or indirect examination. So often you'll get asked a question that may assume expertise in an area that you don't have. And in those cases, it's perfectly reasonable simply to say, I don't have an expertise to be able to answer that question. That often deals with it fairly quickly. Knowing the relevant literature is very important. Now, many experts are not academics, and so a word of caution here as well. If one presents oneself in using education, experience, research as their basis for expertise, then it's sort of fair game to come back and challenge the expert testimony using the literature as well. So it's important to know how much to rely on the research literature as a non-researcher, because the research fields are vast, they're often complicated, they're always limited, and one can pretty easily get tripped up talking research, especially if one isn't used to having that kind of conversation and challenge. And finally, a point here is that it's always very helpful to practice in a mock testimony situation. With the attorney that you're working with is ideal, but if that attorney doesn't have the time or doesn't believe that's a priority, or for whatever reason chooses not to do that, finding someone who can do that practice with you, especially if you haven't done this kind of work very often, can be really, really helpful to really get a sense of what it might be like. Because even with as much preparation as I've talked about and with as many years of experience as I've had, I often get on the stand and there are things I simply might not have anticipated. And so as much as you can work to anticipate what might be coming your way, just the better it is. So I think with that, I'll stop and ask Dawn if she has any comments or other things she wants to add to this section before we turn it over to you, Dawn.
Sure. Well, I certainly agree with everything that you said. And I think we're going to go into more detail on handling cross-examination and some learned treaties when you're presented with an article. So I think we will handle some of that in the fourth section as well.
Good.
All right. So moving on to, this is Dawn Hughes, good afternoon to everyone, to preparing for court. I also think this is an area where we get so focused sometimes on the content we do forget about the process. And I certainly believe that Mary Ann and I are of the belief that our job is to make sure the information that we're trying to convey is accurately perceived, that we're doing our best job to get that information across. And sometimes some of these preparations are part of that equation, and we don't want it to be overlooked. The first is personal appearance. We need to dress for a specific audience. For better or for worse, we know that the legal profession still is quite old school and very formal. Formality is valued. We do have dress codes for many things in our life. We wouldn't wear what we wear to the gym, to the office, or to a funeral, or to a wedding. Right? We'll pick clothing that's appropriate for the venue. And we know that as being an expert, we want to convey a certain confidence. And how do we convey that confidence may be also about what we wear. And as much as we don't like to think this, and as feminists we don't want to believe this, but appearances do matter, and that really is how human beings work. So if I want to be, and I feel like I do have an obligation to be that credible communicator of my opinion, I want to make sure that I dress the part. For men, it's much easier than for women because the outfit is pretty fairly well defined. It's usually a suit is best. That's a general frame of reference. And this is more the art of testimony than the science. Is actually very little research regarding the effect of attire on jurors' perceptions, but there is a certain belief in how we find somebody to be credible and how we find someone to be confident. So for men, it's usually a suit. If it's not going to be a suit, it would also be a jacket with a pair of slacks and dress shoes. Sort of very simple, no flashy colors. Blues and tans are usually quite appropriate. For women, it becomes a little more complicated. I think our attire spans a greater sort of gamut, and you really want to know the venue that you're appearing in. There is certain different cultures, certainly probably here in New York City than in other places that I've traveled in other parts of the country. There's different feeling even here in family court, criminal court, as opposed to Supreme, civil Supreme, and then the top of the hierarchy, federal court. So the general advice is to dress professionally, to dress how your most professional appearance that you have is what you want to wear. And for women, suits are it's a standby. I mean, I have a couple of I call them my testimony suits. Again, usually a blue, a navy, a gray, no flashy colors. And again, if I don't, a suit with a jacket. You want to be aware, especially for women, but for men as well, as jewelry. Do you want to be flashy, or do you want to be more understated? So they're focusing on you and your opinion and not what you're wearing. I have a colleague who always wears bangles, and that's very distracting on the stand because every time she'd move her arm, you hear clank, 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 and that's very distracting. You want the jurors and the triers of fact to have attention to what you're saying, not to what you're moving. And you also want to be aware of what makes you feel comfortable, what makes you feel confident. You don't want to put on something that you don't feel comfortable in because you're going to be sitting on the stand and then not feeling that level of confidence. So trying to make that sort of nice balance between being professional but also being comfortable. Moving on to the conduct in the courthouse. This is something we also tell when we're training psychologists in training, interns and residents. You learn about a person when they walk in the door. The interview doesn't begin when they walk in your office. You know, people are evaluating you from the moment that you walk into the courthouse. Where do you sit when you're waiting? Do you go and sit and talk with the attorney and goof around and laugh? That can be perceived as not taking this seriously. That can be perceived as being impartial, being partial, being biased, being invested on a team, as opposed to presenting information from a much more, impartial standpoint. So perception is everything. In general, some places have rooms for experts. Those are usually taken depending on the busy venue that you're testifying in. But usually I tend to sit away from the family, away from the attorneys, and pretty much keep to myself and, keep myself focused, my eye on the ball, and my internal memory of what I have to do, in a couple of minutes. Time management, I always say hurry up and wait. Court is all about waiting. And that said, I'm always early. I don't want the anxiety of having to be late to the courthouse to interfere with my ability to be calm and present while I'm giving my testimony. So your job is to be professional and on time. And if the courts run late, which they notoriously do, then you'll be fine, and you can use that time to continue to get grounded and to try to refresh and recollect the key points of your testimony. Which brings us to, what do you bring with you? So sometimes what has happened, and it has happened to me, that because I'm sitting in the pews in the hallways, they'll see me looking at something. So is that discoverable? Are you, what were you looking at in the green folder in the hall, Dr. Hughes? And whatever I bring with you, what you bring to the stand is potentially discoverable. Not necessarily all the time, but you do want to be aware and have that conversation with the attorney with whom you're working to know what they're going to ask for. Certainly in cases where we do evaluations, usually they have my whole file before I even get there. But in general testimony, I've actually been asked to provide my notes from the initial contact with the district attorney. And I've had to turn those over. So I have to keep that in mind in what kind of notes I'm writing, and usually they're just the basic, thumbnail sketch facts of the case. And you do want to be prepared to answer, what did you review in preparation for your testimony here today? And if that, usually they're not asking about, well, I read this article on about the CDC about domestic violence. They're usually not asking that. They're usually asking about notes that are relevant to your conversations with the attorney or any kind of evaluation materials. The preparation of visual aids. This is something that I think is very helpful, but not as frequently employed. It really does need to be well thought out and well done. We do know that visual and demonstrative aids can supplement teaching. We do live in this tech-savvy world, and visuals can keep jurors interested. A good visual can clarify sometimes better than words, or persuade better than words, and then it can be also easily remembered and referred to later on. One of the still quite succinct ways of using a visual in cases of domestic violence is the power and control wheel. It has a lot of things on it that we can talk about, especially things that are not physical violence, that are not just hitting. So it provides a nice sort of jumping off point to talk about all the other behaviors that we know exist in intimate partner violence. However, sometimes they can backfire on us, and they can say, well, you mentioned this term coercive control, but that's not on the power and control wheel, is it, Dr. Hughes? So you want to be prepared with whatever visual aid you use, that it is, again, well thought out, and you're prepared for what's not on that slide, what's not on that visual, and why it's relevant anyway. Again, it's not usually done in low-profile criminal trials because time and money are often limiting factors, but we're seeing it a lot more in these tech-savvy courtrooms where they're all equipped with PowerPoint and the jurors have a screen in front of them. So it may be, I think we'll see it more in the future. Coping with your own nerves and personal needs is, again, very important. We know that litigation is stressful, litigation is destabilizing. I always use that as a teaching point, that I get nervous. I can't imagine how victims feel when they're in the courtroom. So our job as an expert is to get control of our own emotional state before we get to the courthouse, because then we're going to be much better able to cope when we take the stand. We don't want to engage in avoidance and denial and think, oh, I'll just deal with it then, oh, I'll be a little nervous. I'm still nervous when I walk into the courtroom. I still get that pang of anxiety, and that's normal, right? But what do we know about anxiety? It's about unpredictability and uncontrollability. It's about loss of control. And we know we're not in control when we're in the courtroom. Someone else is controlling the pace. Someone else is controlling the questions. Someone else is controlling when we talk, when we don't talk, when we come, and when we go. So when we know that, we can acknowledge that and move forward, right? We can take the control back and say, I know it's not under my control, and I can handle that. Also, what Mary Ann said often, prepare, prepare, prepare. There is no excuse to not over-prepare, especially if you're a novice. I remember very, very early on, I actually typed out my whole direct testimony. I wrote the questions and I wrote the answers, and I read it over and over again because I really wanted to be able to articulate what I needed to say. And it was a very good exercise, and I do that now with some of the difficult facts of the case, what I'm anticipating being attacked on. So if you're unprepared and you're inexperienced, then sort of anxiety and intrusive thoughts can certainly interfere with your ability to focus and concentrate. And we know that, right? We know that anxiety and too much stress, right, it's going to affect our attention. It's going to affect our concentration, our information processing speed. So we want the preparation offers a buffer against that and against that distraction from the question. It allows us to be more at hand to what we're doing. You want to keep your mood as best as you can in a good way, right? What are the interfering agents to that? Sleep deprivation. I didn't get enough sleep. I didn't eat breakfast. I'm worried about who's going to pick the kids up from school. Since courts run late, we can't predict it. You want to have all of those other ducks in a row so that when you're in the court, you can focus on what you need to do. And you know yourself. Can you eat? I'm not an eater. I can't eat before I get nervous. I can't eat before I exercise. Some people can. Some people can eat a good breakfast and then go for a 5-mile run. I can't. So you need to know yourself, what can you do? You also want to know about not being naive, that the truth will set you free. I'm just going to go in there and talk about domestic violence. That's also going to be anxiety provoking because you need to prepare, 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 and we're going to talk more about what some of those pitfalls are. The other reason to keep your anxiety in check is that jurors may not know about specific expertise, but they're very perceptive when someone looks nervous. And sometimes that gets misinterpreted as inexperience, misinterpreted about someone being evasive. So they know how to sniff out confidence. So as soon as you can get back to the confidence in who you are and your area of expertise, and allow yourself to be humble and concede when you need to and explain when you need to, you will get back on track. And keeping your nerves in check will have a lot to do with that process. And then finally, I'll end with personal safety, and not an issue that comes up often for experts, and that's because courts are generally safe places. As an expert, you usually come and go while the court is still in session, and family members are in the courtroom, and the perpetrator, if not detained, is in the courtroom, so you usually don't have to interact with them when you do leave. But as we tell the women that we work with, you are your best judge of your own personal safety. You need to trust yourself and trust your instincts. And if you're not feeling safe for whatever particular reason, you certainly should speak to the attorney with whom you're working, but you can always speak to a court officer. They are there to monitor and assure safety, and they can be receptive. Usually there's a hall officer. There's certainly officers at the entrance to the courtroom, and you can always say to them, hey, look, I'm testifying on the 3rd floor. I have some concern. Hey, can somebody escort me to my car? I'm not feeling particularly safe right now. And most often than not, they will absolutely be responsive to that. And again, you can also choose to have someone go with you, and they're waiting out, outside in the courtroom, so you have someone, your own support, to walk back to your car and to debrief with. Okay, and Mary Ann, anything you might want to add to that?
Maybe a couple of things. Mm-hmm. One, that goes back to the time management.
Yes.
One of the things I have trouble with is this when you said hurry up and wait. It's kind of related to that, but it's more when you prepare, you're kind of in the go, ready to go, and then there's a delay. or you were supposed to go on just before lunch, and lo and behold, things take longer, and so there's a lunch break. And so sometimes you sat there for 6 hours waiting to go on, and then they adjourn for the day, and lo and behold, you need to come back the next morning. And so I think that can be unnerving, because it's kind of like being at the start gate and it doesn't start, or it's about to start and then doesn't start. And so it's really back to your point about knowing yourself and knowing what you need to do. One, to simply take that in stride, because that is the way things are, and you have absolutely no control over it most of the time. Although I guess a point is, in some cases, it is useful to say to your attorney, I have these limitations on my time. Sometimes that's respected, and sometimes it's less so. So that's one point.
I think more often than not, they try to be respectful of experts' time and availability. I find that that's the more likely scenario, but it does happen, and it happened this winter in a snowstorm. I had to travel out to Long Island for a case, and one of the jurors couldn't make it, and I had to come all the way home and go back the next day. So that hasn't happened to me in years, but then it's disruptive to my schedule, because then you have to reschedule and cancel clients, and knowing the people that you work with, that this sometimes happens. But, most of us are not testifying on a monthly basis. Sometimes it's several times a year that you try to account for some of that and not let it rattle you.
The other thing about the visual aids, and this is in part dependent on the nature of the court, the resources that are available, and so forth. But if you keep in mind that your job is primarily one to teach, either to the judge or the jury, I found that sometimes, fancy, prepared ahead of time visual aids are probably even not the best visual aids to use. That instead is if one can draw something as one speaks, it can be helpful in bringing the audience, the jury or the judge, along with you in terms of the points you're trying to make. Now that in part depends on how complicated the visual image is, and you don't want to just stand up there being writing while people are standing around waiting. It's annoying, I'm sure, to them. So that's one point, that sometimes it can be helpful to, as on a whiteboard or a blackboard, to use the flip chart, which is often much easier to come by, to use as a place to do the drawing. It also allows you to get up out of your seat sometimes, if the judge allows, to approach closer sometimes to the jury, and to be more interactive, which I think is often very helpful in getting your point across. The other point about the visual aids, and this, I was reminded of this with the power and control wheel, that almost inevitably there are pieces of the control wheel that don't apply to a given case. And I think that's actually very helpful, because if you're, and again, this applies a little more to case-specific testimony, but if it's the case that everything you say applies, all of this applies to this case, and nothing doesn't apply, I think, sometimes that's true, but in other cases when you say, well, actually there wasn't, we're not talking about sexual abuse, or, again, I'm sort of getting into when it's case specific, but it's helpful sometimes to have the jury recognize that there are parts of that power and control wheel that aren't relevant in a given case, so that, they can make that distinction. And I think it adds to the credibility when you're not trying to make the case that everything in the world applies to every single case. And I think that's about all.
I do agree with you with that, because especially when you're given general testimony and you're not given case-specific testimony, sometimes it gives the appearance that the only answers you're given are about that case, because some of the thumbnail sketch. So when you're asked, why do women stay, you want to give the gamut of responses, not just what you think is relevant in that case. And I think that does add to credibility.
Right. I agree. Okay. Shall we move to the next phase? One's conduct on the stand, focusing now on the process of testifying, not so much the content, but the process. So demeanor, I think, is the first and the last point to be made. That is, how do you appear on the stand? And Dawn, you made some of these points earlier. But I think that the extent to which the expert can make a connection to the jury as a whole and or to the judge, the better. And so there are particular ways to go about that. If one appears kind of disconnected and impersonal and rote, that can be a problem, I think. If one appears too chatty and too personable and kind of getting too close and too focusing on too much individuals within the jury box, I think that's a problem. And so finding that balance where, and it takes a level of comfort, I think, that you can assume a teaching role in a very respectful way and putting it in the context of the particular audience. So that may be regional, that may be racial, that may be cultural, that may be age. Generally, there's a range of people in the jury, and so it's important to be mindful of who it is that is going to be evaluating how it is that you come across. Plain English is always very good, and at the same time, not talking so in jargon, for sure, that it appears that you're sort of talking down to the jury. It's very different when you're giving testimony and there is no jury. I find that's a bit more challenging, in part because the judge is often sitting up on the either left or right shoulder behind you a bit. And so you have an attorney out in front of you and you have a judge up behind you, and it's really the judge you're attempting to communicate with, but it may be difficult in some cases to actually be facing the judge. Depending on the tone and the formality of the court, sometimes that's more possible than others. Sometimes that's not a good idea because it would convey a kind of informality that would be perhaps offending in the courtroom. Listening, being a good listener, is a huge skill that will pay off over and over again. Even if you think you know what the question is that's being asked, it is so important to just not prepare your answer so you can answer it right away, but just to sit and listen to the full question for a couple of reasons. One is that the question may not actually go where you think it's going. It's the case that, and this point's in the next bullet, that this is not a conversation. So it's not the case that your attorney has mentioned the topic, coercive control, and your job is just to now begin to discuss coercive control in a broad way. And that's a strategic point that you've decided you want to do. But there's a very specific question, or there should be, embedded in the attorney's question, either on direct or cross. And if you listen to that question, it's very important to address it in some way, because if you don't, then you're perceived as not responsive. And you can be perceived as combative, you can be perceived as evasive, biased, not very smart, not a good listener, all of which are not going to bode well for your perception of being perceived on the stand. But the other reason it's very, very important to listen is because it is important as an expert to be able to read where the questions are going. Because what you don't want to do is to get yourself painted into a corner, having answered a question in a way that turns out that's not at all what you meant. But because you answered part 1, 2, and 3 in a particular way, 4 becomes, well, but of course, given you said 1, 2, and 3. Now, the important thing here is that the most important job on the stand is to be able to communicate the information you have to communicate in a clear way. So you are a strong advocate for your opinion. You want to appear as though that's the case, that you're not a strong advocate, argumentative for one side or the other, either pro or con, but you're not neutral as to the information you're providing. It's not just this casual, oh, gee, you could think of it this way, you could think of it that way. By the time you're on the stand, it's important to be clear about what you can say clearly and have some conviction about. Now, that doesn't mean strident. It just means that you're clear about what it is that your opinion is with regard to whatever the question is. So if you listen well, it's often possible to have some sense of where this questioning is going, and you can frame your answers in a way that help clarify right from the beginning what you're saying and what you're not saying. So the nature of the expert testimony, as I said a minute ago, is not a conversation. This is not just a casual, informative discourse between two people. There are certain rules of the road, and those of you who have testified know this. There's a question, there's an answer. There's a question, there's an answer. And most of the time, you're not at liberty to just go off on a tangent. You're certainly not at liberty to ask questions. You may occasionally, depending on the judge, turn to the judge and say, I'm not clear. Or you could say to your attorney, I'm not clear what you're asking me. But it's not at all. It's just a conversation. And so you have to be careful, because sometimes the questions you get asked are very dichotomous questions, yes or no. And so Dawn will talk a bit more about this in the next section, but while your answers don't have to so strictly just respond to the question yes and then stop, one has to be careful that you don't get trapped with a yes when yes isn't really the whole story. But Dawn, again, we'll talk to you more about that in a minute. Knowing your audience, I mentioned this before, you will testify differently in Brooklyn than you will in Alabama, than you will in Kansas, than you will in California. And you simply need to know something about the culture, the belief systems, the sense in the community even about this case, how much publicity there has been, what people might tend to be knowing about this case before they come to court. Sometimes nothing at all, sometimes it's a high publicity case. Staying within the scope of your expertise. I have to regularly say that's not something that I'm qualified to respond to. And I think it does a couple things. One, it gets it really clear. Just don't ask me any of those questions. And I think it's helpful because, one, it's true, but two, it's helpful that the jury or the judge sees that you're not trying to be all things to all people, which none of us can be. Managing the pacing of the questions. The attorney will set a particular pace. And sometimes it may be a pace that's way too fast to actually think about the questions very carefully. And you might, as just as human nature, match your pace to the questions. But it's possible to slow the pace down just by simply taking a breath, thinking about the question, responding, slowing down the pace of your response so that otherwise you can feel and can get caught like in a runaway train sometimes. The questions just can come very quickly, and if you're in that pace of feeling some pressure to respond to them that quickly, you can get yourself into real trouble. Responding to confusing questions, and I would put in here also compound questions. Sometimes the questions that you get asked are 2 or 3 questions all bundled into one. And so it's quite appropriate to say, in answer to your first part of that question, this is the answer. In answer to the second part, this is the answer, and so forth. And again, if the question is just not at all clear to you, don't guess. Don't assume you know what the question is, but simply say, I'm not clear what you're asking. And presumably the attorney will restate it. Sometimes the questioning, and this is typically by the cross-examination, comes across in a very aggressive or offensive way. Can sometimes even be demeaning. I find that sometimes when people are particularly trying to be demeaning, they won't use your official title. They won't say Dr. Dutton. They'll say, so, Ms. Dutton. They know perfectly well that it's Dr. Dutton, and they've just perhaps examined another examiner for the other side with the title. Or they might even use a tone of voice that's very aggressive or very offensive in some way. And so this point goes to what Don was saying earlier in terms of kind of knowing yourself, being able to not be reactive. If someone, a friend or someone you knew, an acquaintance, were to speak to you like that on the street, you might respond one way. You can't do that on the stand. Or if you do it, you run the risk of undermining your testimony. There are ways to respond in a way that doesn't just assume that's an okay way to respond to you. Sometimes I've been noted to just pause and look at the person like, really? Without saying a word. If you don't know the answer, it's okay to say so. Just straightforwardly, no excuses, no explanations why you don't know the answer. Simply saying, I don't have an answer to that question, or I don't know the answer to that question. I'd have to look that up, or I'd have to think about that. I'm not sure what answer I would give you. Non-defensive style, very important. Another sort of thing that happens is sometimes you might get handed a document by usually the opposing counsel, because your own attorney hopefully has shown you all the documents they're going to hand you before this. But you might get handed a document and somebody says, so, Dr. Dutton, have you seen this before? And of course you haven't, let's say. Maybe you have, but let's say you haven't. So look at line 22. And there's a line that says, client so-and-so said such and such. Or there's an article that says something that, of course, contradicts what you've just been testifying to, or what you might be about to testify to. And you might be asked, well, isn't it the case that this suggests just the opposite? Well, that's kind of a maneuver that might be trying to get you to respond to just a very narrow portion of the whatever it is they're handing to you. So one response to that is simply saying, I need to read this to really be able to respond to that. Or, to understand the context of this, and to buy yourself some time. Sometimes judges will say, okay, should we take a 10-minute break? You can read this article while we're on break, and then you can respond. And it's slowed down the pace of the questioning. Sometimes you're forced to answer right there on the spot, and in that case, you can give a very limited response, perhaps quickly reading the paragraph at least, or the entire sentence, and providing a response, but certainly couching it in the context of, well, given this limited information, and then whatever your response would be. If you make a mistake, simply own it. say, a minute ago I said such and such, but I realized that I said that and that was actually a mistake. Own it, clean it up. Now you may or may not have an opportunity to do that, but you look for ins to do that. Perhaps in a related question, maybe just in the next question. If you simply get out of your mouth, I think I misspoke when I answered that last question, then the judge is going to figure out what to do with that. But at least you've marked it, and you're not on the record as having said something that, in fact, you would not have otherwise wanted to say. Objections to either of the attorney's questions. So the way the process works, an attorney asks you a question, the other attorney has the opportunity to say objection. At that point, that's your stop sign. You don't go on, you don't finish the answer, you wait for them to sort it all out in terms of whether or not you can answer the question, you can answer it in a modified way, or you are not allowed to proceed because they sustained the objection and they have to move on. So that's your cue to just don't say anything else. Another sort of, this is the final one on this section is, and these are among not my favorite questions, would it change your mind if? And there's, as you can imagine, no limit to the number of different variations that one can introduce in a case scenario. And so usually those are questions that are aimed at challenging your opinion. But for one little adjustment, which often gets framed as, well, but you don't really know this other piece. So if this were true, this other piece, wouldn't it change your whole opinion? And it's too complicated to really say very clearly how to respond to that. But one general point is that you can't take one piece of information and reevaluate your whole opinion without considering it first and considering it in context. And so it's useful to have some kind of initial response that says, I'd have to consider that in the context of, or I'd have to consider something else. You have to be careful because you say, well, I'd have to consider whether this other thing is also true. They say, well, assume that's true too. And you've just kind of put yourself right back in the box. But you don't want to be put in a position to make a conclusion based on just facts that are thrown at you and have you consider that and make the conclusion right on the spot. So the extent to which you can say, I'd have to really reevaluate the picture given that, and I'd have to consider how it affects all of the other things that I've talked about. So let me stop there and turn it back over to Dawn.
Yeah, and I would just add on that last point, sometimes I've had it happen where it seems as though the intent of that question is to be so outrageous just to see if you'll concede. And it would be something to the effect, I think I've had this asked twice, would it change your mind if you knew the complaining witness lied about everything? So I understand, that's perhaps their theory, but it seems pretty silly for me to say, well, no, but, sure. So sometimes it's okay to concede a point that's so outlandish because he's not going to go anywhere else with it usually.
Yes. Yeah. And you don't want to be in a position to be yourself appearing so obstructionistic in something that's so obvious. Thank you for clarifying it.
Yeah. And I'm going to talk a little bit about that in terms of the hypotheticals. Which often come up, which I'm not a big fan of. So I'm going to talk a little bit more about cross-examination on this slide because that's where the tension is, and that's where it's pretty, it gets a little hairy. I always say it's, testifying is a thinking person's sport. You do, and even Mary Ann talking about all this, I get a little anxious. There's a lot to think about. There's a lot to consider. So being on your toes is really important, and it is important in terms of the cross-examination. When you think about your expertise and whether you're going to be challenged or your personal life and political views, all of that, you also want to go back to confidence versus performance. And both matter. Both are relevant. But as long as you're giving that appearance of objectivity, that lack of being on a particular side, that lack of partisanship, and then genuine sincerity, I think that is going to come across and be a buffer to some of these challenges. Remember, a question and a challenge isn't a fact. So you're going to continue to have your calm place when we switch over to cross-examination. And when the challenge comes, you can say, there it is. I'm ready for that. I know I'm going to get challenged on that because that's what the cross-examination is intended to do, right? If you read anything about what attorneys learn about cross-examination, it's to, 1, control the witness, and 2, to discredit the witness. So when you're given general testimony about intimate partner violence, we've established a pretty good fact record over the past 4 decades now about what is domestic violence. What are the dynamics? What are the consequences? What are the coping strategies? Why do women stay? We can talk a lot about that, and we have some solid literature behind me. So if they're not able to attack the content, they're going to attack you. I have not had my personal life, political views, anything like that attacked, having done this over the past 20 years. But they still will attack my expertise. And again, they'll do the standard, well, you're not a medical doctor, are you, Dr. Hughes? Right? So I have to say to myself, there it is, and I'm ready. I am an expert in domestic violence, and that's correct. I don't have a medical degree, but I'm a clinical and forensic psychologist. So I wouldn't say, yes, that's correct. I'm going to make it more narrative-based and provide, a non-defensive explanation for that. And if you don't have an MD or a PhD, remember, experience matters. Remind yourself, again, this is the prep before you go into the courtroom, and then you're going to remind yourself in that split second when they switch roles to cross-examination, you do know this work. You do know the ins and outs and the complicating facts that are inherent in domestic violence. You sit with women who struggle with these issues every day. It's not just textbook to you. So when that question comes, again, you're ready for it, and your authenticity as a professional will also be evident. And jurors do tend to believe experts who are reasonably passionate about their work. They like that. They think that that's important, and that's part of that confident communicator of the knowledge that you have. So you really want to remind yourself of those sort of grounding techniques. One thing that we see with experts is when we switch to cross-examination, and not just experts, lay witnesses as well. During direct, your tone is relaxed and friendly. It feels, even though it's not a conversation, accurately pointed out by Marianne, it feels like it has a nice ebb and flow, and you're working together in this nice dance to communicate this great information. And then as soon as, the opposing attorney gets up, the expert gets a little more cold, a little more detached, it's a little more crunched up in the shoulders. And that is felt. You almost get it's a palpable feeling. You want to try to keep it consistent. You want to take your own couple of breaths, your own self-talk as we switch to cross-examination, and remind yourself, these are just more questions. I'm going to be a good listener. Excellent point made by Marianne. You really have to be a good listener, and I'm going to be a good conveyor of this information. The cross-examination technique is to control the pace. And they can make it fast and they can make it slow. They don't want to make it slow because their job, again, is to control you and the content, so they try to make it as fast as possible. That's why the pause can be helpful before answering. Sometimes that's also a danger even for someone like myself who is a quick thinker, who likes to spar, who can get into that sort of debate and dialogue. I've had to train myself that that's not the place for this. If I want to talk about that, over dinner with friends or colleagues, that's great. But that's not the place of an expert. So my job is to really listen to the question and figure out what the answer is going to be. It is a good idea to have eye contact with the attorney who's asking you the question, and then turn and look to the jury to give the answer. So you're sort of going back and forth, and that also allows you to have some pacing capabilities as well. You don't want to stare at the jurors or pick one juror and stare at them because that might make them uncomfortable, but you definitely want to scan that whole jury box and provide some of this information to them. You really also do want to try to give those full answers on cross-examination, even though they're pulling for yes or no or a dichotomous answer. Is it this or is it that? So you can continue to explain and teach, even if you've already said it on direct. Don't be afraid that because we went over it already on direct that you can't say it in. And repetition is helpful for memory retention. It's helpful for them to hear it again from a different way. Usually, attorneys are respectful in general. I mean, we'll always have somebody who has that more hostile, aggressive tone. And when somebody comes at me that way, I know that either that's who they are or they don't really have a good handle on the content. So they're going to try to push me off my game. If it pushes too far and you feel badgered by a particular question and you're just being asked and asked, and the asked and answered isn't sort of holding, you can turn to the judge and you can say, I've answered this question as accurately as you can. I don't have anything more to add on this. And usually a judge will try to step in. The complicated substantive issues, when I think about especially cases of general testimony in domestic violence, this is not a surprise. Again, this goes back to Rule 1, prepare, prepare, prepare. We know what this is going to be generally. Right? We are going to prepare about the myths of domestic violence, what victim behaviors may be confusing to jurors, what things seem paradoxical. I mean, we can do this. We can talk about maybe she hit him too. Why didn't she call the police? If it was really bad, she would have left. All of those myths. That's what jurors want to know. And and that's what our job is. Our job is to really give them that information that we have, having worked in this field, having the experience and that certain expertise. What's complicating for them? That's what you want to be thinking. What is it? What's their obstacle to understanding? And those myths about intimate partner violence will come up repeatedly. And what will happen is on cross-examination, you will be asked the myths, but those will be turned as a fact in this case and not an example of victim behavior, but rather of lack of her credibility. So they'll say, wouldn't a true victim of domestic violence call the police, Dr. Hughes? So they'll try to get the myths as a way to discredit the victim in a certain case. So again, they're not going to be a surprise. You can prepare and have a sense about which ones are most relevant for this case and how you're going to handle it. The hypotheticals are a particular issue that I'm not a big fan of, and Marianne touched about this earlier. They come up a lot in the general testimony because you have not had evaluated anybody in this case or have specific case-relevant material. You're giving this general testimony about dynamics and definitions of domestic violence and so forth. So usually attorneys, and especially on cross, they want to ask you a question relevant to their underlying theory. So you really have to listen carefully because a lot of times the question will exclude relevant factual information that perhaps you even know exists. They'll include factual information that you didn't know exists, right, or you're unaware, or they'll just make stuff up and assume facts not in evidence to ask the hypothetical. So, the answer is should you answer it or should you not? Usually we don't have much of a choice, and this is where we don't have that control. So if you think this set of facts in this hypothetical is legit enough, it makes sense enough that you have enough information to say, even with a qualifier, in this case, in the case as you laid out, or the facts as you laid out, I might think A, B, and C, then you can say so. But you don't have to accept all the hypothetical facts, which are contrary, perhaps for me, contrary to psychological principles, contrary to known facts in domestic violence. So a lot of times I try to avoid answering the hypotheticals because they often don't rise to the level of scrutiny that I need. They don't rise to the level where I can give an opinion to reasonable degree of psychological certainty. So a lot of times I will say, I really need to have a lot more information to provide you with a solid answer to that question. Or something to the effect of, assuming only a few of those factors that you presented, When I know domestic violence to be way more complicated than that, I'm unable to answer that question to a reasonable degree of psychological certainty. And usually they'll back down. Most attorneys don't want to badger their witnesses. And if you're already saying that this isn't going to work for me, you're communicating, I'm not a big fan of hypotheticals, I'm not going to be able to give you a relevant answer, then they might back away. And I say that. I said there's so many elements, there's so many issues that I would want to consider that such a simplistic speculation would do a disservice to the field. I try to offer that so that I can get out of that. And as I said before, if it's something that's so blatantly out there, like, hypothetically, Dr. Hughes, if everything the complaining witness said was a lie, you couldn't say she was a victim of domestic violence. Well, I don't know if I could or if I couldn't. But if she lied and everything's a lie, then everything's a lie. And usually juries see through that as well. Some of the other technical legal framework is, as Mary Ann acknowledged, when you're offered to view a certain document or a learned treatise, a textbook or an article is presented as an authoritative source, and you're getting pushed to answer that it is an authoritative source. I've certainly had Lenore Walker's The Battered Women held up. I think the publication date's 1975. Wouldn't you agree, Dr. Hughes, that this is the most formidable work in the field of domestic violence? So again, if you say yes, then you're wedded to almost everything in that book. If you say no, how are you saying that somebody who was certainly a formidable force in the field of domestic violence has no value here? So a good response is to acknowledge that, your knowledge, right, your expertise comes from a variety of sources, over such and such number of years, including training and experience and education. So it's really important to slow down and not just accept something. And I got badgered on this that case where I got kicked out of a snowstorm, the juror couldn't get there and I had to go back. Because they were asking me about one article. They kept asking, and I said I'm aware of those authors. I'm happy to stop and read the article if you'd like me to answer more definitive questions about those conclusions, because the attorney's just reading the abstract. They don't always know what they're reading. And, of course, the attorney didn't want me to do that, and the judge didn't want me to do that. So they moved on finally from that question. So even if they give up perhaps the battered women or battered women syndrome and go to other things, you do need to be able to answer the question, how do you know that? How do you know that's the definition of domestic violence? How do you know what physical violence is? How do you know what coercive control is? And when they ask you, what do you read to stay abreast in the field, again, not a trick question, Sarah Palin. You have to have an answer. We have to have an answer about what we do. What do we do to stay abreast in the field? How do we continue to have our knowledge? Participating in a webinar, sponsored by the Violence Against Women Office. That's one of the ways I stay abreast in the knowledge. So having an answer about how you're keeping up with these sort of technical scientific issues that we have. And then the yes-no. Again, you don't want to seem like you're an adversarial figure and that you're fighting small points. When it's appropriate to say yes or no, and if you can answer, do so. A lot of times I try to use that's correct, that is correct. For some reason that just feels more comfortable for me. But when it's not a good answer for a yes-no, it's where you can use a clause. And going back to, 7th grade grammar, where it is sometimes true that, or even though it may be true that, although domestic violence is often about, it's important to examine the unique characteristics in every case. So, being able to buffer the ultimate answer that really gives a broad, more narrative, educational statement to the jury on that question, is much more helpful. And again, we are not in control of this process. We are just one player in this large field, right? Our job is not to win this case, right? Again, our job is to make sure our information is accurately perceived and perhaps not twisted and mangled, and we're going to do the best that we can. But sometimes, and it depends on the judge and it depends on the attorneys in the courtroom, sometimes you get pushed into a yes-no. And, I'll say, I'm not able to sufficiently answer that question with a yes-no answer without misleading the court, or I'm not able to sufficiently answer that question. And then sometimes the judge will say, well, move on. She can't answer it. and that doesn't look so great either, but sometimes you can't. So don't panic. The courtroom is full of many, many constraints, and you're going to go and do the best you can. Keep your eye on the ball, stay in the game, and if the attorney needs to fix this one on redirect, they will, but knowing you can't win every battle. And then finally, just some other don'ts, which tend to rise more in cross-examination because the nerves are a little more on edge. A lot of people talk about humor. Very few experts can do that effectively. Don't try to joke because it usually backfires. Jurors are sitting there all day on those hard benches. They might think it's funny. When a judge makes a joke, you can chuckle because usually the judge, is the one who wants to appear funny, not you. And you don't want to be a smart aleck. You don't want to join in the power struggle with the cross-examining attorney and the sarcasm that sometimes ensues. Don't want to get defensive. Again, I often equate sometimes the work as an expert as the work I did with the court-ordered perpetrators of domestic violence, right? My job was to communicate some information to them, but it was very hard to get it to them sometimes. But I couldn't join in the power struggle. So sometimes I like thinking of when the attorney's asking me these questions, which I know are couched in these myths and misperceptions, I think of it as this is someone who just doesn't get it yet. My job is to try to explain it a little better without being disparaging, without being hostile, without being demeaning. You catch more flies with honey than you do with vinegar, and the jury's going to see those efforts to teach and explain. So you don't have to over-advocate. It's not your job to win the case, and you're a much better asset to the case if you demonstrate your own poise, your own confidence, and your own expertise. And I think that is that. I'm sure something about all of that, Marianne?
Well, I think you did a fabulous job. So perhaps given the time, we should turn to the questions if there are any.
Yes.
This is Sue. I just want to thank you for just such a great presentation, and I just wish you could keep talking for another hour and a half, actually. Those were some of the best practical tips I've heard, and I think many people on this webinar will agree with that. So thank you so much. Cindine?
Yes.
There were a couple questions there I saw.
Yep.
So if you want to ask our presenters the questions, that would be terrific.
Certainly. One of the questions we got in the chat box is whether you would recommend addressing your answers to the judge if it's the kind of case where there is no jury present.
Yeah, I think Marianne addressed that. I've done a few bench trials and a couple of sentencing. So at sentencing, you are addressing the judge. Physically, it depends on how the courtroom is set up because you're, cocking your head backwards sometimes to see the judge. But I do try to move my chair, and I try to look directly at the judge, absolutely.
Thank you.
I think one has to read the situation. I think some judges want to remain impersonal and don't want you to talk to them directly. And I think in other cases, it works just fine, and it's, in fact, a better strategy. So I think one has to actually read the tone and the tenor of the court and the judge to determine if that's a good idea.
I agree. Thank you. Another question we got was whether you have any tips for responding to challenges based on the fact that you didn't interview the abusive partner in preparation for giving your testimony, that maybe you only had information from the victim's point of view.
Yes, I'm glad somebody brought that up. I was thinking about that along the way. And it's often the case that when I give general testimony, the cross-examination question that you can know is going to come is, well, you haven't even seen so-and-so, have you? You haven't even talked to anybody in this case, have you? And then a simple, no, I haven't. I've not been asked to. And stop there. Because if you try to explain, it sounds defensive. It's the attorney's job to put whatever the context is he or she wants to do. And often the follow-up question is, were you asked to see so-and-so in this, to evaluate so-and-so in this case? No. Thank you very much. And they're done. Because it's your credibility that they're challenging.
Exactly.
And if the the attorney makes it clear that you weren't asked to do that, then it's on the attorney, not you.
Thank you. Dawn, did you have anything on that? Or?
I would agree with that. And any time I have done general testimony, invariably that question is asked. And sometimes in trying to attack the credibility would be, and you haven't evaluated her mother either, and you didn't speak to her brother, and you didn't speak to the attending physician, and they'll go through the list. And I'll say, as I stated, that's correct. My job here was to provide testimony about the general, effects of domestic violence, and I didn't evaluate anyone in reference to this case. But sometimes they'll go on because their job, they're trying to just discredit you and the opinion that you're going to offer. But again, if you know it's coming, you're less likely to get rattled.
And so I think we have time for one more question, right?
Sure.
Okay. We just got one in. Is it appropriate in a yes or no question to respond that you can't answer that without an explanation?
I think if you have good information to answer that question, if you say that, they're not going to want to hear your explanation. So that's why sometimes using those push-pull techniques, whereas it may be true in some cases, not all cases, is the victim isolated from her family, something like that. So if you want to communicate that opinion and you give that qualifier, you probably won't get the chance.
Good.
I would agree with that. And often a judge will just say, can you answer the question, or answer the question as asked.
And then move on.
And then you're done. So I think Dawn's, what she talked about is the strategy is far better, to try to clarify it in your answer without asking permission to clarify your answer. You may get cut off and you may get told to just answer the question, yes or no. But you're more likely to be able to give a clarifying answer if you just try to do it.
Another great tip. Thank you
Correct.
very much.
Yeah. So many great tips. This is Sue Ostap again, and I really do want to thank our presenters. Cindy, and I think we got the questions, yes?
Yes, we did.
Okay. Dawn and Marianne, there's a comment here at the end that one participant literally is having her, the first time she's going to testify is coming up this week. So she has a 2-day trial this week, and she says, I feel much less anxiety about it and know better how to prepare. Thank you. I think that's awesome. Sums it up quite wonderfully. So there you go. Just in, honoring everybody's time, including yours, I'm just wondering, do you have any closing comments that you want to share with the group before we thank you once again for really a very informative webinar?
I think one just piece of advice would be, don't do this in isolation.
Yes.
Yeah,
that you need to have support. Yeah. And even after you testify, it's normal to feel slimed. I can't tell you how many countless times I've called Marianne on the drive home from somewhere just to debrief, because we do the best we can, and sometimes we become pawns in a very larger system. And even though we've done the best we could, we become the conduit for a lot of bad facts, and sometimes it just feels icky. So you do need to have some support. The content is upsetting. The process is upsetting, so having someone to debrief with and get support from is very important.
Yeah, that makes total sense. So just to everybody who's on, if you are testifying already and we don't have information about you, please send us information so we can figure out whether or not there's attorneys in your area who are looking for experts. So please write to Cindene, which Cindene, CINDENE @ncdbw.org. And it's in the chat box, but for those of you who are just listening in, there you go. So that would, and then the other thing I had posted was, Dawn and Marianne both said you have to really know your stuff. And one of the things that we've been trying to collect for some time now is different people's experts resource lists in your bibliographies. And we know that different people use different ones depending on the type of case it is, the facts of the case. But if that's something you have and you could share it with us, that would be really great, because we are trying to compile information that we're very happy to share back with people who are participating as experts. So please write to us. Let us know what you're doing out there. And again, Dr. Dutton and Dr. Hughes, that was fabulous. And you can see why you two are such good experts, because you're really good teachers. So thank you very much. And on behalf of the National Clearinghouse for the Defense of Battered Women, thanks to both of our presenters, to Cindine and Dot, and to everybody who participated today. Okay, bye.
Thank you.
Bye.
Thank you.
Bye-bye.